an additional award necessarily of substantial size may be needed to reflect a sense of public outrage, emphasize the importance of the constitutional right and the gravity of the breach, and deter further breach must consider without regard to all the circumstances of the case. It is of evidence that the assessment of compensation for injury or loss, which is neither fiscal nor financial, presents special problems for the judicial process, objectively justified by evidence, reason, and precedent. Subjective feelings of upset, frustration, worry, anxiety, mental distress, fear, grief, anguish capable of objective proof or of measurement in a matter of terms. What I'm saying is this: translating hard feeling into hard currency is bound to be an artificial exercise. There is no medium of exchange or market for narco and policy exercise more than a legal or logical one. The award must be fair and reasonable. Fairness be gauged by earlier decisions, but the award must also measurement in matter of terms. Hard feelings are nonetheless real in human terms. The courts and tribunals have to do the best they can on the available material and persuasive practical reasoning available in the calculation of financial loss or compensation for bodily injury. Petitioners claim a sum of Kenya shillings 7 million as compensation. It's not clear how this amount was arrived at. In the submissions, there is no serious argument to support this amount. I wish there was. However, considering the nature of the violations, the legal principles discussed above, the nature of the violations, and bearing in mind the fact that it may not be easy to quantify infringement of fundamental rights in a case of this nature, and do the best I can, I find that an award of a global sum of Kenya shillings 4 million would be reasonable in the circumstances. Courts do not and cannot countenance a denial or violation of constitutionally guaranteed fundamental rights, which are a cornerstone of our legal system. It is the court's primary duty to protect these rights, these basic rights of the people vis-a-vis actions by government agents. As Albert Camus, a Nobel Prize winner, once remarked, quote, either cooperate with injustice or fight with it, end of quote. Elie Wiesel, a Holocaust survivor, once remarked, quote, we must always side with the rule of law, end of quote. It cannot be denied that the police actions in this case were inspired by a noble intention of fighting crime, geared towards the betterment of the nation and its people, and particularly the youth. But then again, it is important to remember this ethical principle, quote, the end does not justify the means, end of quote. No matter how noble and worthy of admiration the purpose of an act, but if the means to be employed in accomplishing it, it is simply inconsiderable with the constitutional parameters, then it cannot still be allowed. The court cannot just turn a blind eye and simply let it pass. The court will continue to uphold the Constitution and its enshrined principles. So the final orders. In view of my analysis above, I find and hold that the fourth and fifth respondents violated the statutory provisions governing conduct of police officers while searching women. I also find and hold that the actions violated the first petitioner's rights in that they failed to act in the best interest of the first petitioner as provided under Article 53 of the Constitution and the Children's Act, and that their conduct was a gross violation of the first petitioner's constitutional right to human dignity, freedom, and security over a person, and the right to privacy. I find and hold that the first and second and third and fourth respondents are vicariously liable for the actions and or omissions of the fourth and fifth respondents complained of in this petition. In view of my above analysis, and guided by the law and authorities enumerated above, I conclude and find that this petition partly succeeds. Accordingly, I find the appropriate orders which command themselves for issue in this case are as follows. 1. A declaration be and is hereby issued that the fourth respondent's conduct of searching the first petitioner in the presence of male police officers and all other members of the public and photographing her or allowing or permitting third parties to take her nude photographs was a gross violation of the law and an infringement of our constitutional rights to dignity, privacy, and our right not to be subject to degrading treatment. 2. And declaration B and is hereby issued the manner in which the police strip search the first petitioner and the other students was a gross violation of the statutory provisions governing seeking to quash the conviction and sentence of the first petition in Baricho criminal case number 262 of 2015 is hereby refused on grounds that the law provides for right of appeal or revision against the said decision. 4. And declaration B, and is hereby issued that the first petitioner is entitled to damages for violation of our constitutional rights to dignity, degrading treatment, and privacy. 5. Judgment B, and is hereby entered in favor of the first petitioner against the respondents jointly and severally for a global sum of Kenya shillings 4 million by way of general damages. Lastly, the above sums shall attract interest at court rates from the date of filing this petition until payment in full, no orders as to costs.
Thank you very much. I also appreciate the judgment, and I request for copies of the judgment.
Certified, or you want the advance copies?
Send us electronically, kindly,
I
if
would
possible.
like the hard copy.
Electronically, we will send